Ok. a contract. Good morning, everyone. How are you today?
Good
Can
morning,
you
ma.
hear
Good
me?
morning, ma.
Good morning, ma. Yes.
Can all speak before we
Afternoon,
go
ma.
back to our chat box? Can you hear me?
Good afternoon, ma.
Yes, ma.
Yes, ma.
Yes,
Good
ma.
afternoon, ma.
Okay. So, okay. So you can all hear me. Thank God it's another day. And today we are going to be looking at another term, another element of contracts, and another element that makes a contract. And so we are going to be looking at consideration. So let's start off. Of course, I've given at least 6 minutes, and we are 299 here, 299,300. And I think on YouTube we should be 30 something. With that, we are good to go. So let's commence. So, like the rules that we have already, these are like that we use the chat box for all questions, all comments, and all answers. By so doing, you will not interrupt me, and we are not going to have cases of those that will leave their speakers on that may interrupt our class. And again, I don't like that you put your matric number in the chat box. The reason being that it's going to affect the flow of our discussion, okay? But then there's a way Zoom will generate the attendance for me. In fact, if you are the type that just come in and you leave, I will know when you actually enter the class and when you left. So do not be bothered about your attendance. All of that will be taken care of, okay? But let's just use the chat box for our discussions, answers, and questions. So let's start off. So who can tell me what consideration is? I said today we are going to be talking about consideration. If you can remember the last time I told you that we have some elements of contracts, things that makes a contract, makes an agreement a contract. Remember we said, oh, contracts is an agreement enforced by the law. And if that be the case, what then makes any agreements, what makes it enforceable? And those are the 4 elements that I mentioned. And I said offer, acceptance, consideration and intention to create legal relations. And so we've discussed the first two. We are on consideration today. And so I'm getting a definition from Oduye. It says, consideration can be in form of action or money. That's beautiful. Okay, so Salako says consideration is a price that is paid to validate a contract. Good job, but I would really go with that of Oduye because it's not in all cases that you pay money. That time this is action that is used as a consideration, okay? And all of that. So Magaji says consideration is a key element of contract that refers to what each party promises or gives in exchange for the other party's promises. Okay, thank you very much. Okay, I like, Oyegbola also says that losing something to get something. That's also a very good layman definition. But then it may be a layman that gave this definition, but then it sounds very appropriate. And so I also want to encourage you that do not go online to search for answers for me. Okay, I'm not expecting a perfect response. I love when people are original, just tell me the way it comes to your mind. It is better you do that now that we can correct that than using AI or Chrome or whatever to get me responses, which is not from you. So there is really not much that you can gain from it, okay? So just give me responses as it comes from you. And like I told you earlier, I do not bite. And really in my class, you can never make a mistake, okay? You are just telling us the way it comes from your mind. And it's better that will give you the appropriate position of things, okay? So you can be assured that no one is going to feel intimidated, okay? Or feel my responses are not acknowledged. Okay, thank you for all that is coming in. Queen says, consideration means act of thinking carefully about the situation before giving your consent. It is better. So that is actually like you're accepting. This definition that Queen gave me is like an acceptance. Consideration means giving something, okay? It's like you're giving something in return for another thing. And it can be in form of an action, and it can be in form of money. Okay, so consideration actually is like, a lot of contract has to do with bargain. You saying, oh, I want to purchase this from you. I'm going to pay this amount of money. The other person saying, oh, I wouldn't go with that and all of that. So in the process of that, there are promises that are made. The promises of, oh, I'm going to give you this phone for the sum of 50 naira. Oh, I'm going to give you this thing for that. Let's say, for example, you have a lecture notes, Anyway, that's what has been the position in those days, or even till now, you can you have a friend, a colleague that you told her, oh, please, I want you to please copy my lecture note for me. Please, I need to copy my lecture note for me. If there is a promise from that other person that, oh, don't bother, I'm going to copy it from you. If by tomorrow that your friend did not copy it for you, he hasn't done anything, according to law, he hasn't done anything wrong. He promised you can decide to fail. But if you are told that your friend to copy the note for you, that you are going to give him 5,000 naira or you had even given him the money that he should copy the note for you, and he did not copy it, with the fact that you had given him consideration is that money. With the fact that you are giving him that money, it gives you the right to report him or to do whatever, because it's more or less that he had breached a contract between you. That money validates that agreement between you, and it authenticates, or would I say, give that promises between you. It gives its action. so that the other person can fulfill its promise with the money you are going to give to him or to her. So the best way to define consideration is that consideration, you can describe it as a basis for bargain. It is described as a basis for bargain. So consideration can come it consists of either rights, interest, profits, benefit that you accrue from one party to another, forbearance, detriment, loss, responsibility that is given, suffered or undertaken. So I want you to look at this very well. You say with all of these things that I've mentioned here, it's like you forsaking something for another. You having to go do away with something in order to get something. So if someone promises you something, you have a contract, you also would have to give in something. And so that is what we call consideration. So like I said, consideration is a basis for bargain. Most of the times, I don't know if you have heard this legal maxim, we call it quid pro quo. That means giving something to take something. Nothing goes for nothing. So you have to give something to take something. That's what we call quid pro quo. So consideration doesn't need to be in money, like I said. You don't have to pay money to say, oh, I have given you consideration for this thing. It can come in form of an act. It can come in form of forbearance, or even a counter promise is sufficient. Okay, this is what I mean. If you say, oh, I promise to copy a note for you, the other person can say, okay, if you copy my note today, I can copy yours tomorrow. So that promise, giving it back for your promise, is enough. Or today you said, today I'm going to copy your note for you. And you all agree that, oh, tomorrow he's going to copy. But after you had copied the note today, tomorrow the other refused to copy the note, at that point you feel you have been cheated. That's a breach of an agreement, a breach of a contract between you two. All right. Okay, so and a person from my phone says it is like a collateral. Not totally. Collateral is a different thing. It's just that it is something you give back for something. Okay, let's not go too deep. Collateral is at its own definition. Okay, so we then, in contracts, in law, we just don't do things just the way you want to do it. We have rules that governs everything that we do in law. And so we have rules that govern consideration. Like I've mentioned that consideration is this, is that, is this. It doesn't just go strictly like that. There are rules that covers or that relate to it, that if you must go into a valid contract, you have to put it to consideration. And so let's look at the first rule. The first rule says consideration must have some value, but it does not have to be an adequate value. So I don't know, there are times, I don't know if you've watched any of this foreign film. You could just hear a lawyer saying, give me $100 there, or give me $1. Immediately they notice, oh, you are in a trouble. They could say, give me $1. Then immediately you give them the dollar, they'll just tell you, oh, you've retained me to give you legal support or to represent you in this case. It's just $1. But then, in law, for you to have a very, very valid contract, something must exchange hands. So Yunus asks a question. It says, do the elements follow each other in like a form of hierarchy or order? Can consideration come before acceptance? Of course, Yunus. I want you to look at this very, very well, that question very well by yourself. Is it possible to pay before you bargain? I want a response. Is it possible for you to get to an iPhone shop or a Nokia shop and give them money before you ask for the price? So of course, all of these things need to actually go in that way. It's like a nature's way of doing things. Although we'll see that at some points, in as much as we will learn also that past consideration cannot be said to be a consideration, we still have some exception to that. But until we get there, it is good that if you have it in your mind that that is the way contract works. In every contract, you cannot just see somebody on the street and give them money before they even tell you they want to sell something, which is an offer, before they give an offer to you. So I hope we've been able to respond. I've been able to give you a solid response. Okay, so Michael said, when you enter a public transport and you are in already before you know the price, remember, like I said, it is at your detriment that you enter a public vehicle without knowing the price, except it is all these vehicles that most of the times we know the price. Like I said last week, I mentioned Moremi Car Park. I said, as a person, I don't know of any of you that, that may not know the price. Now, the vehicle, the cost of transportation on Unilag Transport or on Unilag campus is known to me. So I really can just go into the vehicle. So that means Mudashir is not in this class. Mudashir Deborah, of course you are not in this class. So I'm going to write your name down. It's as if you are not in this class. And seriously, I'm going to take it up by sending it to your dean. Because if you had been in this class, you wouldn't have given us your matric number. Okay, so let's go ahead. Like I was saying, remember when I mentioned entering into a vehicle, when you want to enter in such a transaction, like I said, going to Moremi Car Park, there are times you just enter that vehicle. Because I know the price, I would enter, I would drop and all of that without even saying anything. That I compared that to an implied contract. Or will I say contract by conduct, that you did not even say anything. But then going into a vehicle without knowing the price is as if in your mind, you do not even mind what the price is going to be like. Because in most contracts, I would say, you need to know their price. Except maybe there is scarcity of, maybe the scarcity, you don't have enough vehicle on campus. That everyone just rushed in, and whatever they call the price, in your mind, you have assumed in your mind, I'm going to pay whatever the price would be. Okay? So, Michael Olukayode. So, do you then get me? And are we still going? Are you okay with this response? Anyway, let's keep going. Like I said, that consideration must have some value, but it does not need to be adequate. And I gave you an example of some lawyers in fact, we can have it here, because that means you have retained, but it doesn't have to be the amount or that you can afford. I say, for example, if a promisee sells his car for 1,000 naira, it is a soft, if Mr. A and Mr. B, Mr. A sees Mr. B, who is in their need of a car, and he says, oh, don't bother, just bring 1,000 naira. I'm going to sell it. It is adequate. It's an adequate value for the car. You cannot then bring an action to say, oh, the consideration that you furnished me is not adequate. No. Remember, they both agreed, because that person that asked for 1,000 naira, he wasn't forced to make that statement. He wasn't under duress. He made it, he asked for that money willingly, that, oh, don't bother, just bring 1,000 naira. Then it's sufficient enough for me. So I want you to have it in your mind that consideration must have some value. It does not really have to be an adequate value. I hope that has corrected some wrongs or some assumptions in your mind. So number 2, let's look at the second consideration. It says consideration must move from the promise. If there is a promise, there must be a consideration. If there is promise, there should be a consideration. Okay, I'm writing names down to send. So I think this one is in HR. Balogun. Okay, so these are the names I'm actually sending because I don't think you've been in our class. Maybe. Okay. Okay, so like we're saying, number 2, consideration must move from the promisee. So this is actually simple. An alternative way of saying that only a person, okay? Only a person who has furnished consideration in return for a promise can actually bring an action to enforce the promise. Okay? It is a person that had paid money for something that can say, oh, paid money or give an action or lose something in the process of a promise that can actually claim or seek for enforcement of such a contract. So in the normal run of contracts, plaintiff is the promisee, okay? He may have given a promise, and the defendant most of the time may be the promisee who had failed to do his part of the contract. So then, just as it says, consideration must move from the promise. The promise brings about consideration. Remember, you can ask questions. If you need me to come back, you can always call me so that I can give the explanation better if you don't. But I think so far, we've actually been doing a simple explanation. So number 3, consideration must be executory or executed.
Excuse me, can you explain the number 2?
So what is an executory contract? An executory consideration? I'm asking a question. I want you to start dropping it. What is an executory consideration and what is an executed consideration? Okay, so Oluwadamil, I don't know, this name is not in full here. At Oluwadamilade says I should give explanation again. So I mean, Oluwadamilade, if there is a promise, there must be something to be a consideration for that promise. If there's a promise that, oh, you know what we call promise is that there is an agreement. If there's an agreement that I want to drop this phone for you, okay, there must be something that the other person will forego to get that phone. So that's why we say consideration must move from the promise. The person who receives a promise must lose something for it. Okay, so I'm still expecting those that want to give me the explanation or the definition of executory or executed contract, consideration. Like I said, don't go online. If you go online, I would know. So it's better you just don't tell me, okay? So Formula said, executory consideration is promised to be performed in perfect. So Okpara says an executory consideration is one, the promise process of being considered here. Executive consideration is one which has already been. Okay, so you guys are doing well. Abdul Latif, I want to believe. You said well. Adeola has said well. So just like the way it implies, and because we have actually been treating, we have actually said some things about these words before. When you say consideration may be executory, that means it may be money that or it may be something that you want to forego in the future. I gave a kind of explanation or an example last week. Who can give us an example of executory consideration? An executory an example. And I gave, if you can give me an example that I gave last week, about executory contract and all. So I think we can use it now too. Executory consideration. Yes, insurance, perfect. Paying ahead of something, good job. Thank you, Daniela, as well. You know, give example of a colleague when I was in school who would most usually have made payment before they start giving her food and all of that. So you have done so well. Oh, thank you, Zoom user. Your name is not there, but thank you. So thank you very much. You are really following this class. So then execute. So for those that may not have gotten it very well, what we mean by executory consideration is a consideration to be done in the future. Okay? Consideration that, although it may have actually been partially done, but then it is yet to be concluded. Oh, maybe you are paying in installments. You may have paid a little, then you want to pay the rest in the future. All right. So that, okay, look at this person saying you paid LAPO money and has refused to pay. So I don't understand, Rukayat. Please, if you can come up with this. Okay, so and that is executory. I hope you understood. For those that may not have gotten, because I should not assume that you all got it. So like I said, executory consideration is that which maybe consideration, you will have to lose something in the future for what bargain you have done or for what agreement or contract that you have entered into. Okay? It may actually have been partially done now, but then it is yet to be perfected. Consideration is still in process. Then executed, what is executed consideration? Executed consideration is consideration that is perfected already. For now, let's assume you went to a restaurant, you bought the meal and you made payment instantly. That is an executed consideration. Do everybody get me? Do not be shy. I would respond to all your questions. Okay, I hope you all got executory and executed consideration. Good job. So let us go to consideration. That's number 3 that we just concluded. Then number 4 says consideration must not be illegal. Consideration must not be illegal. So let's say, for example, you actually you met with somebody, or you entered into, you told somebody, I want you to, anyway, it's more or less like just talking about an illegal contract as well. Saying, I want you to go and do this thing wrong, you know, I don't want to mention age. I want you to, you met with a thief, or you met with all these people that does things wrong, and say, if you do this, you are going to, I'm going to give you something which is illegal in return. Okay, so let me just give you a very good example of that. So, consideration that it's either contrary to the rule of law or immoral, saying that, come, if you give me this phone, I don't know that, let me just say it as it is. If you give me your phone, you can have, maybe is it phone, you can have phone with that person. A person says, you can give me phone for SEX. You understand? All that, they are immoral. That's illegal. And it has no value in the eye of the law. Do you understand my example? Okay, Ayomide also mentioned drug dealers, and I mentioned the illegal, immoral, although I don't want to nail it on this, you know, say you want to take something for sex. That is an illegal contract. So I think Dauda says I should explain executed consideration again. Okay, let me just quickly what it means. Executed consideration, just like the way Ladine implies, it means a consideration that is perfected already. You know, we mentioned a lady that went to a meal, to a restaurant. She paid ahead of time. she paid for like 3 months payment for a meal. But then you as a person can just walk into a restaurant and make an instant payment after you have been given your food. Okay, so I hope that is on that. Oh, thank you, Ayomide, and I think it's the same Ayomide because I'm seeing two Ayomide here. You have said well, trafficking, drug traffickers, saying you are taking drug and maybe drug for money, drug for whatever, and all of that. Those actually, they are illegal and it should not be accepted in the face of the law. You cannot sue people like that to court. But I don't mind for other examples, or if you have a question, if you think you have not really gotten my explanation. So moving forward, number 5. So a promise to perform an existing obligation is not consideration. So let's say, for example, if Mr. A promises Mr. B that Mr. A, will do something which he has already been bound to do before, it cannot be said to be consideration. So let's assume that most of the times we always do, that's what we do in this part of the world. There's a security man in a car park, especially car park around, let's say, for example, in the school. And of course, the security, they're expected to look after the vehicles around. They're expected to sit around the garage and ensure that the vehicles are secured. But you just felt, oh, please, I want you to, please, I'll be going somewhere and I'd like you to help me watch my vehicle. And the guy says, oh, you have to pay some money for it too. That is not, although that can also come in form of corruption and all of that. But then that person's official duty is to watch over those vehicles. So paying him again is like, you are paying him for an already existing obligation which he has been given to do. Do you understand my example, please? Okay, thank you. So, Unwo Kocha says human trafficking, can it be said to be an illegal contract? Unwo Kocha, I know you, it's perfect, is a perfect example for illegal contract. Human trafficking is illegal according to our laws, and in fact, according to international laws. All right. So, thank you very much. So, I think we should move to the next phase of our work. Okay, so let us look at. Okay, so Ayomide says I should explain number 5 again. So what I meant is that, and I gave this example. I want you to read this example very well. Or let me just give you the example that I gave you earlier. So someone says, okay, don't worry. I will answer you. Da Silva, I'm going to answer you. But let's do that explanation of promise. A promise to perform an existing obligation is not consideration, like I said. I said, let's assume, Ayomide, I hope you can hear me. Let's assume you have you came into the school with your car and you want to park in the management's car park. Of course, we have security guards that are employed originally to watch over the garage. And you told the man, oh, gentleman, I'll be leaving, I'll be coming very soon. My car is here. And the man said, oh, you have to pay for watching over your vehicle. So you paying that man is not good consideration, because you are paying that man for already his obligation in that garage is to watch over the garage and the vehicles. So you paying him is not good consideration. It will not be seen as a good consideration because it is not what he has been employed to do here. There is to watch over the vehicles. And so I give the example here that when you give somebody something that is bound to do before, that is not good consideration. So Ayomide, let me know what you think about that, my explanation. So Da Silva says that what is the difference between past consideration and executed consideration? Now, past consideration, let's say, for example, yesterday you were together with your friend, or you are just together with your friend, and today, and you wanted your friend to help you go to Ikeja, or let's assume you have a friend, you are in Ibadan presently, you live over at Ibadan, over there, and you have something you want to do in the school. You have your friend that lives around Yaba, and you told that your friend, come on, I want you to, I want us to do something together. You go to this place. When you get those parcels, I'm going to give you this in return. I'm going to, or that I want you to go and get that some parcel for me. And the guy said, oh, I want you to give me money for the parcel I'll be delivering for you. And you are telling the guy, but last week now, I was kind enough to give you money. Can you not use the money that I gave you last week? Although I know it was a gift. Can you not use that money for what you are doing presently? That is past consideration. Executed consideration means consideration that today you both perfected that thing. You don't have to wait till next year before one person perfected the side of the consideration. Today you told him, go and deliver this thing, you make payment to that person delivers. Is that understood? Okay, the person that says I should do 1 and 2, please. I think you don't want us to leave. I had explained and explained those ones. So I just want you to, anyway, this will be on the internet, on YouTube. You can always listen to it again. So Ayomide says, so do you mean we can get the money back legally? Because I went to beach and we were told to pay to the security for parking our car. Remember, it depends. The security there, where did you park? Did you park within their garage or outside their garage? Because I could remember there was a time I went to that beach area. I think I went to one of the a mall there. We parked outside of the mall, not inside of the mall. So you have to think of that very well before. Of course, if it was within the garage of the company or where you went to, and he was employed to watch over that garage, there are some of these payments that they make. It may be that they also pay the owners of the space. So you have to, all of these things, they come with regard to their own specific nature. Okay. So Ogundele says that, can executed consideration be more of cash and carry, ma? Yes, cash and carry. Something you paid and you got your value immediately. Okay. So I think we can move on from here. Like I said, if you still think you do not understand my explanation, kindly go to my YouTube channel and listen to today's class. All right. And do well to subscribe to my channel. Okay. So let's go ahead. Let's look at waiver of contractual rights. So the rule that performance of a duty, there are sometimes you may have done something, and when you slip over your rights over something, you may eventually not be able to claim for damages or for anything. So the rule that performance of a duty already owed to a promisee is not sufficient. It's not sufficient consideration that applies to waiver of contractual rights as well. So where a contracting party waives his rights under a contract, only or in part, the waiver is not binding unless consideration is given for it. This is better understood and well discussed in relation to obligations that are created by debt. You know, so let me give you an example so that before I can give you a better understanding of this that I just said. So if Mr. A owes Mr. B 100 naira, okay, and Mr. B tells A that he will accept 75 naira in full satisfaction, A duly pays that 75,000 naira, 75 naira rather. The question then be, can we go back on the promise and demand the balance of the debt? So it's earlier, we have tried to show that A could not succeed as a plaintiff if his performance was only that he was under a duty to do it. But now, our concern is how A will fare as a defendant if he is sued by B for the balance of a debt. Okay, so the waiver of a contractual right here is that, there are times that you were entered into a contract or someone entered into contract with Mr. B. And it could be that you are going to give me, okay, I install something for you in your house and you are going to pay 1 million naira. And or somebody that it mostly happens in business transaction, that you gave somebody had gone to another shop to get something with debt, and after getting those things, he couldn't pay up. But because the other man wants his money right away, he says, oh, if the money is 1 million naira, just make payment for 750,000 naira, and I will let it go. And I will let it go. But then, after some times, the person made payment of 750,000 naira, and he came back again and says, oh, no, I'm not letting it go this time around, though. I want to take my money back. What do you think as a person? What do you think the position of the law should be? I want to hear you in the chat box. Or do you want me to repeat myself? Okay, this is my question. Okay, the question I ask is, Mr. A has a factory, and in the factory, he supplies shoes. Mr. B went to Mr. A factory. And when he got to Mr. A factory, he was given some goods. When he got those goods, he couldn't sell, or he sold and used the money for something else. Then he couldn't pay her. Mr. A, who owns the factory, approached Mr. B and said, oh, your money is 1 million naira that you need to pay me, but I need my money now, so you can just pay 750,000. And the Mr. B, who is the customer, made payment for 750,000 naira. And that was it. And subsequently, Mr. A came back again and said, I want to take my 250,000 naira back. What do you think should be the position of the law? What's on your mind? I'm seeing all this. Okay, so let me see. I don't think Mr. Hay has the right to request for 250. Anyway, sorry. You know why I ask this question is so that we can, because when it comes to law of contract, you know, when we started, you were taught by the, in your first topic or your first second class about the common law that we inherited by through Britain. You know, so under common law, the law said that, there is nothing like you have paid parts. You cannot, you still have to make the payment of 250,000 naira. Although, you know, human reasoning would feel like, but it is you that said that you not bother paying that money. But under common law says he still has to pay the 250,000 naira because there is a strict, they have a contract that is existing. And the contract says that it is 1 million naira. And if you are not paying the 1 million naira, if you have not paid the full 1 million naira, that means you have not done as the law had said. Okay, let's hear what Naji said. Thank you for all those that have made their comments. It's just that your comment keeps coming in, so I don't want to I want everybody to have their comment here. So Naji says that, look, someone is keeping your, so that Mr. Hay has no right. Okay, sorry to say, under the case, we call it Pinel's case. It is in that case that it was decided by the court then, by the House of Lords, that if there's any scenario like that, Mr. A, who is the owner of that factory, still have rights to the remaining 250,000 naira. He still has rights to the remaining 250,000 naira. But then, although there are some things that the law actually looks at that point in order to ameliorate the injury or ameliorate the thing or whatever that Mr. B may experience. And one of these is that, one, payment of a lesser sum at an earlier date than the due date at the creditor's request will be a valid consideration. Yes, exactly. Arrow do, because the contract started with 1 million naira. Exactly. That was the reason why the court decided that. Although the okay, so yeah, some people, okay, so Balogun says, can the 750 be considered counter offer? Remember, they have concluded the place of offer. They have left offer. They have even gone past consideration because they've entered the contract. The guy has taken the goods. So Balogun, you cannot say it is counter offer, okay? It is just things that normally and most often happens in business. And that's why, law of contract is very important when it comes to management students. These are the things that happens most of the times, okay? Okay, but then I want you to look at, so that's it for that. I want us to look at, okay, so I'm trying to, okay. So I think at this time, I know you all are you are not happy with that case. And remember also, you treated the law of equity. Please, are we together? It's as if we are in class and you're saying a lot of things. You know, that's just common law. So I want you to read promissory estoppel. And that is where the rule of penal case has been, it has been reduced. The law of equity has come to the aid. Okay? So let us read what is here. So here it says that promissory estoppel, the rule in penal case can again be circumvented by the doctrine of promissory estoppel, where a party has waived or promised to waive his contractual right against another, and that other party has changed his position in reliance on the waiver or promise. It would be unjust, I repeat, it would be unjust to allow an action against him on the original contract to succeed. Equity is fairness, and so it does not look with favor at a man who promises relief to another and then goes back on the promise. So with this promissory estoppel, that means that's your word, that statement, that's your that consequence negotiation, or would I say bargain, for 750,000. The law has stopped you from then going back on that promise that you have made. Is that understood? So the rule or promissory estoppel says equity should come to the aid of Mr. B, who is the customer, and that Mr. A, who had promised, cannot go back on his promise to say, oh no, because that was our original agreement, and I have a document to back it up. Okay? Okay, please give me a little, excuse me, please. Okay, so I'm seeing some people loving the rule in promissory estoppel. Okay, so that is for you to see that although we have laws, and that this is the reason and the place where you would appreciate the initial topic that you had. If we hadn't treated that initial topic, you will not be able to appreciate what we are doing now. So in law of contract or in law generally, we normally have something we call common law. But then outside of common law, then there's equity. Why common law can be a bit rigid is that some people, they take advantage of equity at times too. And that is why if you look at the rules in equity, most of the time they will say equity aids, he who comes to equity, who can finish it? Who can finish that? He who comes to equity,
Must
I'm
come with clean
waiting for
hands.
you. Oh, wow. Do I have law? Beautiful. Must come with clean hands. So a lot of people, you are doing well. So a lot of people actually are misusing equity at times, okay? Some people may want to, so that's why at times common law can be a bit rigid. But then, you still have to look at some people that actually are doing things the way it's meant to be done. Okay. So I think we should go ahead, right? Okay, so I just came to check our people on Zoom, but then Okay. At this time, I think we should move to another topic because we've been able, at this point, please, to everyone, are we on the same page? We check those on YouTube if they have any question there. Okay, so okay, okay. Yes. Okay. Okay. All right, I don't think we have any question. That's fine. We're on the same page. Okay, so Oloyede Deborah says that, can we apply the rule that says consideration need not be adequate to this case? Okay, so remember that when we're saying this, we have not gotten to the place of our explanation. Or the example I gave to you, they are past consideration stage. They are in the place of enforcement or, you know, if at least you want to say that, but then that's not the way the law will look at it. Most of the time, you are done this consideration mostly even before you start the contract. You'd have said, oh, just pay ₦1 and take it before you commence the contract at all, or before you even sign papers. Okay, so Agbona Bere said that I should go back to waiver. Oh. What I only mean by waiver is as simple as that, as the example I gave to you. So what I said there is that you entered into contract with somebody, Mr. A owns a factory, and he had given some goods to Mr. B. Mr. B couldn't pay up at the required time, but Mr. A needs money so much at that time. He said, oh, instead of paying the balance of ₦1 million, which you're expected to pay, bring 750,000 naira. So what the law says there is that you have a right to waive. And even if you have waived, subsequently, we have a rule under Pinel's case who says that even after you have waived that right, after you have waived the payment or something, you can still come back and say, I don't want to waive again, give me my balance of 250,000 naira. And that was how our discussion started. And our discussion or that rule was savaged by promissory estoppel, which says that if you have made a promise, if you have said something, you cannot go back on it. Deborah, what do you think now? I hope we are on the same page. Or sorry, Isioma. Please, let's quickly move ahead. We have a lot to cover. Okay? So let's go to intention to create legal relations. Okay, so I want someone to talk to me. What do you think intention? I'd open it, but then, okay, let me go back a little bit. What do you understand by intention to create legal relations? What do you understand by intention to create legal relations? Yes, Olayinka, it means that according to promissory estoppel, the law will protect Mr. B from paying 250,000 naira. Okay? Beautiful. So let's go next to our class. Our next class is intention to create legal relations. What do you understand by intention to create legal relations? Okay, okay. Thank you, Ayomide. There should be beautiful Olawale. The person willing to be bound. Beautiful is good. Okay, you are doing well. When one is willing to enter into any legal relations. Good job. Okay, so let me just start by saying that. Remember, let me give you an instance. You went to Yamoria's place. I don't know if it's everyone that likes Yamoria here. For a few of us, we like Yamoria's food. and you went to Salado. I think Salado will be okay for everyone there. You went to Salado and you went with your friend. You told your friend in your class, you're in class, and you said, oh, let's go to Salado. I'll buy rice for you. And at that point, you said, oh, you buy rice for me. Oh, tomorrow I'll also buy rice for you. Okay? Tomorrow I will also buy rice for you. And so you went to Salado today. You bought the rice. He ate and it was filled. And tomorrow, after class, you told him, oh, it's time. Or let me not use tomorrow so that I won't confuse you. Yesterday, you went to Salado. Yesterday, when you were in class, after class yesterday, your friend said, oh, let's go to Salado. Mr. A told Mr. B, let's go to Salado to go and eat. I'll pay for the food. And Mr. B, looking or seeing that Mr. A is so magnanimous, says, oh, tomorrow I'll also buy something for you at Salado. And when they got to Salado yesterday, Mr. B ate Salado and they went home. And today, after class today, Mr. A went to Mr. B that today is your home. Let's go and buy Salado and eat. And Mr. B says, come, I'm not buying, I don't want to buy anything. Just leave me alone, and left. What do you think about, can Mr. A sue Mr. B for not fulfilling his promise? Why? Okay, Queen said he can. Okay, tell me why you think he can sue Mr. B. And Rachel Tajuddin, I want you both to also tell me why you think he cannot sue Mr. B. Okay, so Okpara said there must be a legal practitioner before you can say it's backed up by the law. I don't agree with that. So Rachel said there was no legal agreement. Beautiful. What makes it a legal agreement? What makes something a legal agreement? It's not a contract. Someone says it's not a, so what makes it a contract? I wish you can just tell me what can even make it a contract better. When it is backed up by law. Okay? Legal enforceability makes it. Okay, let me give you another scenario. I'll give you another scenario. So there is this uncle of yours, or let's assume you want to travel abroad. Or this way, you have a house at, you live at a place maybe very close to school, and you have another friend of yours that lives very close to school. Mr. A and Mr. B, they both live close to school. So because Mr. A is facing some, or not even anything, because Mr. B, they are both friends and they were thinking, oh, if we can stay together, we can be reading together, we can do things together. Mr. A sold or left his rented apartments because Mr. B had promised him that he will allow him to come and stay in the house. He left his rented apartments and used some part of the money that that his parents gave to him. They used it to furnish Mr. B's house the more. And immediately he left that place. Mr. B said, please, I don't want you to come to my house again. I changed because I don't want my parents to see you in my house or something. Now, looking at my example A and example B, which one is good contract? I'm waiting. Which one is good contract? Yeah, example B is because you notice that in that case of B, in the example of B, he has lost a lot of things. Aside from the fact that he had left the place he's living, even had given some part of the money to refurbish Mr. B's place. But Mr. A, in their own case, it started as a promise. It wasn't something huge. It was just a promise and all of that. So that is, you know, and so, you know, when we get to intention to remember, as a school, as an institution, we are not here to confuse you. We won't give you an exam that would confuse you. So let's just go straightly, because some people may be, okay, look at it, they both agree on that example B. Okay, so, okay, yeah, that's fine. They both agreed. Good job. So I want you to know that I'm not here to confuse you. I just want to ensure that we are together. You know, at times I just have to make this kind of example in order to have you together with me on this as we're going. So yeah, I said, in addition to offer and acceptance and consideration, okay, the law requires a third element, which is named intention to contract, intention to enter into legal relationship, as an essential requirement in a valid contract. It is very essential. So we have different types of way we can classify this thing, this topic. We can classify it under social and domestic agreements. We can also classify it under commercial agreement. So I want you to know that every commercial agreement has intention to create legal relations from the onset. If you approach somebody in their shop, you didn't go there to play, and they are not in their shop to play. They are not your family member. So you go into their shop, purchase something. In the both, the law sees the both parties having intention to create legal relations. Do you understand this, so that we can just move away, we can clear that? Or do you think you don't really understand, or you have a suggestion or something to come up with? So in every commercial transaction, there is always an intention to create legal relationship. It is not negotiable. You cannot negotiate it at all. So, and I also want you to know that when we are talking about, whenever we want to talk about intention to create legal relation, what the court normally look at is an objective test. So what an objective test means is that what a reasonable man on the street will see as the position of things. What if the court just sits and like, oh, I want to make this decision, that they can call anybody walking on the streets and give them the fact of this case, and whatever that man says is called a reasonable man, because that means anybody that, if you have 10 people, at least 7, 8 people would agree as being the position of things. So when you're talking about intention to create legal relations, the court looks at the objective man test, which is the reasonable man test. So I mean commercial agreement again. Please listen. Every commercial agreement, both parties have intention for legal relation. They have intention to be bounded. They have intention that if any of them breaches it, anybody can sue them to court. That's what it means to create legal relations. That means if there's a breach in that contract, the one that has suffered the breach can sue the other person to court. Okay, so Koyu, I don't understand this question. He said, is that where the presence of juries is required? What do you mean by juries? Please, I need you to explain it better, please. I want to clear this thing from your mind. Please, quickly explain it. Okay, a jury. We don't practice jury system in Nigeria. I hope you know. Jury system is practiced in the United States. And that is where maybe in the, I hope you are talking about the jury, all those, when you're talking about those, is it 10 or 12 set of 12 people that you see in criminal cases that sit together with the judge? Oh, no. And remember, when it comes to contract is basically civil. So jury is used in criminal cases in the United States. We don't use jury system in Nigeria. Okay? I wish, and I think it's not very okay at this time that you have not sat down. You should at times, you can just take it at a leisure. Go to court, sit down in court and sit down. Nobody, they won't hold you. Court is a public place. Just ensure your phones are on silence and you sit at the gallery so that you can experience all of these things at times, okay? You can go to magistrate courts. You can start off with magistrate court. There are a lot of civil cases that has to do with pure contract in magistrate courts, okay? Edits, or is it edit? Yes, edits, Akman. That means Edet has not been in this class. Just came in and wrote his matric number. I really mean it. I'm going to send this list to the dean. You are in business education. Okay, so let's keep going. So here, you see, let's talk about social and domestic agreements. So when you mean social and domestic agreements, those are the, agreement between husband and wife, agreement between, there are times the husband may be so happy. Maybe, have you ever experienced it that at home, daddy will be so happy and say, oh, tomorrow I'm going to buy this for you. I'm going to give you 2,000 naira. I'm going to give you 10,000 naira. And it comes tomorrow, he say, go and wash my car. Oh, go no. I hope these people writing their names knows that they are going to the dean. Okay. So that mommy and daddy will say, if you wash my car for me, or if you wash the plates or something, if you do this, I'm going to do this for you. And you would do everything that is needed. You would have done all, and they won't give you what they want to give you. Especially when they promise you a huge amount of money, or they promise that, oh, if you do this for me, I'm going to, let me see whatever that is big that they may want to say they want to do for you. Anyway, I don't know of a car. I think a car is too much. But there are times that they promise you that thing and you hold those things in your mind. In your mind, you'd be like, because someone said, my daddy hasn't bought the bicycle for me after doing my part of, they will say, go and do this. And in your mind, in fact, sometimes you would have told your friends that my daddy will do this for me, and they won't do it for you. So I am here to tell you that those are social agreements. They are domestic agreements that cannot be backed up by the law. They do not have intention to create legal relations. Oh, hey, buy iPhone. I think that's fine. Thank you, Badamosi. There are times, Olawale, they will say, oh, don't do that, I'll do this for you, and they don't. And the meaning, when you say iPhone, especially when they promise you the latest one, and they don't do it. Or they would, at times, you would even go and tell them they would just snap at you and like, you don't even know what the situation of the country is. But then you need to have known what the situation of the country was before you made that promise. But I'm here to give you is it a bad news now? That is just an ordinary legal social domestic agreement. It doesn't have any force of law attached to it. You can only be angry. You cannot sue them to court. Okay? So that is just for that. Also, I want you to give you this it again, that it may not be like that in all cases. Okay, yeah, Morakiyo says, if you get first class, I will buy you whatever. Please, get the first class. Even if they don't buy it for you, you will have done yourself a good thing, okay? Please get the first class. I'm telling you, even if they don't buy you a car, but I think they will buy you. I'm thinking in my mind that they will give you something. Please, let's go ahead. So I said in this, that I said, it is to be noted that this may not be the case in some other circumstances, okay? So I want to give you this circumstance, okay? There is this case. There is this woman. So the husband, before he died, the husband, before the husband married her, had a child with another woman. So during marriage and even during the marriage, the child was living with the woman. And you know, at that point, she now becomes the mother, isn't it? She now becomes the mother. And so after the death of the father willed some property to the child. And so Mama told the child that, come, let us sell this property. Then we can take this money and all of that. Mama sold the property. I didn't give that child the money. In that case, it is not a social domestic agreement. It has a touch of the intention to create legal relations in it. I hope I've not confused you. Do you agree with this example that I gave to you? Oliver, we are going to come back to you. Okay, so someone said they don't understand. I've said, it's a story, and I don't want you to let me repeat that story again. So someone asks, what is the line separating it? This is the line separating it that I've just said. Your grandparents willed a property for you, and your parents went behind you to go and sell the property. Or they promised you that let them sell the property, they will give you the money. They have to give you the money. It is your money. You know, that one is bigger. It is yours. They can't say, but you are my child, and it was my mom and my dad that gave you that. Somebody said for colo money. I can't say, but you know, you don't want to sue your parents for colo money now. You want to be nice. We can actually bring in colo money too because it's your money. Okay? But most of the time, you notice that they would have bought shoes. What my parents used to do for me then is that, what of the shoe I bought for you for Christmas? What of the clothes I bought for you and all of that? So let us just go ahead and move ahead from there. Okay, so let's go ahead and say, let's go on to commercial agreement. I think at this point, we have agreed that every commercial agreement has intention to create legal relations, backing it up. But I also want you to understand that there are some commercial agreements that do not have intention to create legal relation, backing it up. And that is in the place of honor clause. And that mostly happens in football matches, all these bets that you do all around. If you do bets and they didn't give you your money, you cannot sue them. Because if you are careful enough, you see that in their terms, they would have written it as an honor clause that we are not bound by any of these agreements. But let me tell you the reason why it is like that. It is assumed that you should honor them, that you should assume that they will honor whatever they have said. But that doesn't mean you can sue them to court. And this is the reason why that came up. You know, in those days, they use stamp. They use the stamp office. Is this stamp office? No. They use post office to send their responses to bets and all of that. So there are times that these bet offices may get, you know, you may not get a post until like 10 or a month after you had sent the post. At times, they might get 50, 100 posts on just one bet. and they would have to take the first person that sent the post. Now, the other 49 people or persons would come up and want to sue them, that they also have sent something. So with that, the law create this strategy that you just have to honor that they will do the right thing and that they won't go back. And in fact, you know, some of these people that play bet also, a few of them are corny. You know, I'm so sorry to use these statements, please forgive me. If you are a very good and a right and a upstanding people, why play bets? So for those that play bet, they also want to cash out. And so they may want to go to any length to cash out on the bet company. You rarely see a case against bet company because the agreements are swiftly done in such a way that the law expects that they will honor whatever they said, and so you cannot sue them because it is in their clause that they cannot be sued. Okay? So I think that is clear enough. If that is clear, I'm going to collective agreements. I'm going to collective agreements, and if you need me to explain, please call me, but I don't think we should do much on it. You can always get this on my YouTube page. Okay, so let's go to collective agreements. What is collective agreements? I want to give you an example, and a very wonderful example of it. I will start from, there are some times that you have a colleague that has a car, a vehicle, and you all live at Abule Oja. And because of that, it picks you, it brings you to school and takes you back. Or maybe I shouldn't go to that collective agreement. Let me just use what I have strictly, because my class here is, you are not law students, so I don't want to go too much into what we bring up something. Okay, so I think that would rather go to social agreements. The agreement, the one that I have here is that, you know, our trade union under the law, originally, any agreement that is made with trade union as regard employment and labor, it is said not to have legal backing. It does not have intention to create legal relations. And anything collective bargain, maybe trade union, they sat with the government and they agreed on some terms. Under the common law says that the employers are not bounded by those things. So that's when you see that in this case, the English law, the English court said that a collective agreement was not intended to be legally enforceable, and accordingly, the court will not grant relief for breach of such agreements. I don't know what is coming up, what you're thinking presently, but I want to think for you, and I want to think you're saying, oh, well, that is unfair. If a labor, because one day or another, or one way or the other, and looking at our employment and our HR people here, this is exactly where you really work, where you work with or where you work on. It's quite unfair, where some people, they would have protested, they would have done a lot of things, and the court is saying they are not bound by that. The employers are not bound by it. But then it has been modified by different laws that we now have in our different countries now, under the Nigerian Labour Act, and so on. It has been reviewed now. So if, like, for example, you know, recently the Nigerian NLC, they met with the government and they now agreed on the present minimum wage. and it has been made law on the federal level. In fact, Lagos State has gone beyond the minimum wage, and other states are also coming in. So when it comes to collective agreements under the law, collective agreements, according to that case, the law says that it is not legally enforceable. But then, with the advent of different laws, that's what we call statutes, it has been reviewed. And the Wages Board and Industrial Council, all of them, they have now made provision for giving binding effect to recommendation of Wages Board, to recommendations of Labor Congress, or would I say the labor aspect of the country. Do you understand? Can we go ahead here? Can we go ahead? Can we go? Okay, so Dauda, what question do you have? You said no. Do you not understand what you mean by collective agreement? Please, what question do you have? Just expressly give me your question. So while you are writing your question, I'm trying to go to my next, okay, so if I want to, okay, collective agreement, I will repeat myself again. Collective agreement means that, for example, in the cases, I said agreement between corporation and trade unions. That is where collective agreement mostly is used, in the cases of corporation or trade unions. And the law under these segments of this intention to create legal relations, it says that any agreement that is made by trade unions does not bind the employers. That is the initial law under common law. I hope you have not forgotten common law. But then, over the years, it has been seen, that law has been seen to be unfair on the trade unions, on the employees who are taking time to do protests, who are taking time to sit down with these people, and afterward they will say, oh, all that they've done is in vain. So then this has been reviewed under different laws of different countries. Now, we have it under our industrial acts in Nigeria, our Wages Board and Industrial Act in Nigeria, that says that any agreements or any proposal or any recommendation given by Wages Board will be approved and will be adhered to. Anything that maybe the labor, the NLC actually sit down together with the government to do will be approved, will be seen as having legal backing. It will be enforced. For them to come together and sit down on agreements or make recommendations, and recommendations are approved by remember when I gave example of the recent agreements between the federal government and the NLC. You would see that when all of this, when each party, when they met, they still have to work under the recommendation of the Wages Board. And it was the recommendation of the Wages Board that informed the government or the federal government to agree, I think, to 70,000 naira as the minimum wage. And according to the law now, that agreement is seen to have that the parties had legal intention. They have intention to create legal relations. I hope I've been able to clear doubts. Yes, thank you, Lawali. That's just the position. Queenest, why didn't you charge your phone very well before now? You have a class. You should have charged your phone. Remember that maybe you should tell mommy and daddy to get you a power bank. Okay, most of the time you guys play on social media. Okay, Queens, I wish you the best. You can always go back and look at my YouTube, Okay, let's quickly go on to contractual terms. So, what are contractual terms? I hope we have been able to clear elements of contracts. That takes us, our last slides take us to the final phase of terms of contract. And I hope we are good to go to our contractual terms. Okay, what then is contractual terms? We know, we had talked about elements of contract. We had talked about the classifications of contract. But then, most of the times, you always have reasons before you enter into a contract. There are times you may not even need something, but maybe because somebody had told you that this thing is good. Or, I don't know, a lot of you, in those days when we enter, but I don't think that's the position. A lot of you now, you take Uber, you take all these beautiful vehicles. You may not experience what I'm about to give now. In those days, when you board on this Molue, I think now they call them red buses, because I don't think they allow advertisements of products in BRT. But these red buses, when you board them, they will be advertised. There are times that you may not need those things, but based on that advertisement, based on the fact that that person has said all these things, all these good things about that thing, you may want to buy that thing. And remember, when you buy it, it's as if you have entered into a contract. So at times, it is not, those are the terms of contract. The things that prompted you to enter into a contract, those are terms of contract. And at times, those things that prompted you, most of the times, you can then put it into papers. Maybe you want to buy a land at Magodo, and you got there and they were saying, oh, this land is very good, it appreciates, you have good people living in this area is serene, there's no this, there's no that, those are the things that surrounds it. And all of these, you can put them in papers. That this place that you're about to take, belongs to Mr. B, who owns, you can hear I think recently there was a legal battle between the owners of the land at Magodo and the federal government, or maybe Lagos State. But the owners, they won it. All of these things are the things that could prompt you to enter into that contract. And so when parties contract, they exchange promises, and certain rights and obligations arise of the exchange of promises. So the rights and the obligations, they are actually the terms of the contract. These terms may be expressed and may be implied. Okay, so if this person says, oh, this thing that you're about to buy, I'm telling you, it is the best that you can see in the market. It is very good, it is functional, it is this, it is that. And you as the person says, oh, don't worry, I'm going to give you 50,000 naira for that thing. If that is the case, you can then enter into, those are the obligations and the rights that are entered into it. The obligation is that, on the part of the person that's advertising, is that this thing will be good. Okay. And the person that is making payment has the rights also to claim for maybe in the future, if what they had heard, what he had been told is not the situation of things, he has the right to go ahead to court to sue.
Okay. Some people know that she's married.
Some people are saying, please, let us use this, our chat box, for serious things, okay? All right. Let's just make it formal. All right. So, contractual terms. Okay. So, and these contractual terms can be expressly stated and it can be impliedly stated. The expressly stated part is where you say, oh, this thing is good. Buy it, is functional, is this, is that. And the other part says, oh, I'll pay 20,000 naira for it. Those are express terms. But there are times that those terms are not expressly said. Because let me be sincere, let us be sincere with ourselves here. It is not in all times that you lay the procedure for a term for a contract, you all say the real thing, you all say the thing as it is. There are times that some things are not stated, but you both think in your mind that that is the position of that thing, because we cannot say everything. So a few things are not stated, but they are part of the contract. And I said implied terms are those that are not specified, but they are implied. So the importance, please, I want you to listen to this very well. The importance of implied terms is because of the fact that express terms may not necessarily state every details of the intention of the parties before they enter into a contract. Okay? Most of the times, express terms will not state exactly what everything that a party wants in a contract. Okay. So let me give you an example. You went to Yamoria, went to a shop and says, I want amala. Or maybe they have the way they said, they have a plate, said, I want a plate of amala. And you sat down. Impliedly in your mind, the amala has to be hot. Isn't it? The amala has to be hot. But remember that you did not say it when you were buying the amala that I want hot amala. But it's an implied terms on your part and on the part of Yamoria's sales reps that amala will be hot. Right? But seriously, I can't hear the person who's okay. Let me go and check. Someone said a person's whatever is not, but I can't see the whatever. Okay. Oh wow, now okay. You said someone's mic is not okay. Achinachi. Okay, so I think we are good to go. I hope you can see my screen. Okay, so. Oh. Okay, so I gave an example of Yamoria's. You see, did you now understand what I mean by implied terms? I hope implied terms is well understood now. Okay? We can now go ahead with our implied terms and understanding it. Those are things that in a contract, you may not expressly state it, but then it is what you both know should be the custom. This is the way it is in this trade. You know? Understood. So I then, I want you to also understand that implied terms, okay, terms may be implied so as to meet the intention of the parties. Okay, so the importance of implied terms from the fact that express terms may not necessarily state every details of the intention of the parties in entering into the contract. Additional terms may be implied so as to meet the intention of the parties. Let's say, for example, if you get to court, a case gets to court, there are times that court themselves, they would imply some things into a contract. And the reason being that they want to ensure that the intention of the parties is well articulated by the both parties to the contract. Okay, so implied terms may arise in three situations. Number one, where custom or trade or practice indicate that such is the term. And that is the example that I gave regarding going to Yamoria's. It is the custom in that trade, in buying amala, in eating amala, that it had to be hot. It is the custom, all right? So that is an example. Another one that is where there are terms that are implied by statutes. So I don't know what is the imposition of different board on your course of studies. But as a lawyer, we have something we call our Legal Practitioners Act. And under the Act, it gives us the laid down rules on how we charge. So even if I did not charge you from the onset, I can charge you. It can be impliedly, it is an implied term that I'm going to use the legal practitioner charge form to charge you. And most of the times, we charge in percentage. So if I want to draw an agreement for you on a property that you bought for 1 million naira, my percentage is 10 million naira. If the property is 10 million naira, my percentage is 1 million naira. Most of the time, we don't need to talk about it because it is implied by the statutes, by the Legal Practitioner Act. Okay? And also, another type or another situation where this can come in is where the court themselves implied that. And I made mention that, you know, there are times that a case is taken to court that they were confused regarding something. Okay, so let's say, for example, I think it was in this class that I mentioned that there are situations where the law will say that, oh, all of these things, when you are producing a product, you should list all the ingredients that are in the product. But some people, because they are dubious, they will not list those things that are allergic, that people can be allergic to. If that be the case, and such a case is taken to court, that this person did not list all that is stated, the intention of the law or the reason why that is because of the allergic element that the court wants to ensure that is part of it. So this is what the court will then state. The court will then want to look at the intention of the parties. Then the court will now imply the intention of the law, or even if it's the party, we then imply the terms into what is before them. Okay? And so that is for our preamble in contractual terms. I hope we are moving forward. I hope we are together. Okay, so that is it for terms of contract. They are obligations, they are promises. They can be expressed, they can be implied. Expressed are those that are clearly stated. Implied are not clearly stated, but then most of the time you cannot say it all. And so we have examples and the reason why these are. So when you're talking about terms, terms can be conditional and terms can be in warranties. So conditional terms are those terms that are so important that if they are not adhered to, it can lead to repudiation. So repudiation means that that contract will be seen as if it didn't occur. That means, oh, if Mr. B has paid some money, he will be giving his money back. So when there's a condition, he said, oh, I want to buy this phone from Mr. You approached, oh, you know, there's this fish that is called, I hope that everyone can relate to this. I wish I can use a relatable example. But this is an example I want. There's a fish called, I think it's not, I don't think it is, I don't think it's a sardine, but you can call it sardine. It has a lot of bone around it. Yoruba will call it, who can give me an example, a name that Yoruba calls sardine? Shower, exactly. There's something about shower. It has egg, as in the egg can be so big that it makes the fish very big. And some people like the egg so much that you can even buy, bonga, I think it's also bonga fish. I hope so anyway. You can buy shower fish because you want to eat the egg. And when you meet this mama that sells fish and you say, I want to buy fish, I want to buy shower fish that has egg in it. And you told Mama, without that, it is the egg, exactly, it's the reason why I want to buy it. If there's no egg in it, I'm not going to pay. If Mama cuts the fish and there's no egg in it, you are just enough not to buy the fish. Am I right? And those are conditions. Those are conditions that you had laid before you went ahead with the contract. And those are part of the terms of contract. If those conditions are not adhered to, then you can decide to take back your money to say, oh, I'm not going ahead with the contract again. Although there are times that some people are so nice, you'll be like, but this woman is an old woman. Okay, instead of giving you 15 naira, I'll give you 14 naira. And that's the place where you say you can repudiate it or you can pay for damages. That's what I meant by this statement, that it can be repudiated or it can be, you can pay damages for it. Okay, so going ahead to warranty. Warranty are not very, very much that same. In the case of warranty, if it is breached, you can only be entitled to damages and not to outright repudiation. You can only be entitled to damages and not outright repudiation. But also, when you are talking about terms of contracts, do you understand me? Because I want to ensure that we finish our slides. I only have one more slide left. I hope we can go ahead. So when you're talking about exemption, exclusions, okay, so for Oliver, please, not now. I want you to please ask this question again. By the time I'm done, we'll answer that question. So let's talk about exemptions, exclusions, or limitation clauses. You know, most of the time, these also are part of the terms of some contracts. Okay? They are most of the time, they are part of contract. So when you are entering into contract, there are times that you have told yourself that I will not, exemption means you are exempting yourself from liability. Say, for example, look at that honor clause that I mentioned when we're treating exceptions to commercial bargainings under intention to create legal relations. There is an exemption clause which is called honor clause there. That we are not going to be liable to whatever. If you are not paid, we are not going to be liable. That is example of an exemption clause. There are times that you get to some garages, they will say that cars are parked at owner's risk. Those are exemption clauses. But under the law, let us look at how exemption clauses should work. Because there are times that maybe you are on an holiday with friends, or you went for holiday with your friends, with your family, and at the reception desk, they won't have told you anything. At the reception desk, they will write a receipt for you, and you go to your rooms. But most of the time, when you get to the room, they will write properties at owner's risk. Those exceptions, those exception and exclusion clauses are not approved under the law. They are not accepted. They are seen as being unfair under the law. Because these people know that if they write it at their reception, people mostly will not want to take their rooms. Because how can you take a room and you leave your things, your belongings there, wherever you are? You will not be convenient. You will not be happy. You would be scared that, oh, my things are not safe. So the law sees such exemptions as being cruel. And here I said that in the spirit of the principle of freedom of contract, okay, exclusion clauses are perfectly legitimate. They are accepted. And the courts are normally, they are prepared to uphold their validity. Okay? If before you enter, like that example that I've given to you, going back again, that honor clause, of course, the courts, wherever you want to take that honor clause to here, in this part of the world, it will be accepted, it will be approved. Because before you enter, before you play the bet, they would have written it there boldly that honor clause, we are not going to be liable. Or let's say, for example, you both agree to a contract that I want to buy this phone. But if anything happens to the phone after tomorrow, it is you be the one that will go and repair it. You cannot come back to me and say, oh, I should be the one to repair the phone. So those are clauses, yeah, there are exemptions that when it is written down or when it is expressly stated, you parties had agreed to those terms. But it would have been cases where parties did not agree to it, but you just suddenly meet it there. And so I said, going forward, I said, there are, however, circumstances where the court will hold that such clauses are inoperative. So, in doing this, they will usually take into account the relative bargaining power also of the parties. You know, there are some times that even, in fact, there are times that you enter into some contracts of exemption, that there will be exemption clauses. But because one person have an upper hand, that exemption clause will be agreed by the one that has a lower bargaining power. You just say, well, let me just go in like that. At least it's something that I can manage. So when such a case is taken to court, the court want to look at the fact that although you both agree to this exception clauses, but $10, you have a higher, you know, looking at this person as a higher bargaining power compared to this person whose bargaining power is very low, but maybe he had entered into that contract, you know, as being a term of contract because he feels, the situation of the country is not smiling at all. Let me just go into this contract. If such cases are taken to court, with the rule of equity, with the rule of fairness, the court wants to look at those that have the lower, we want to be on the side of those that have the lower bargaining power. Am I understood? Am I understood? Okay. So okay. Oliver C says no. Oliver, please no. You are saying no. Everything. Okay. Because okay. Oliver, I would like you to please go ahead and listen to this teaching again after the class. All right, you can always go to the YouTube and listen to it because I'd actually given you examples and that will really help you, okay? It's not as if I'm trying to waive your question. I'm just trying to ensure that we all carry and we have a lot to do, okay? Okay, so I give you an exemption examples and I said document that's relied on that contain notice. Oh, geez. Okay, so let me just be able to put this in here. Let's see if 22 would work. Okay, so I said a document relied on as containing notice of excluding clauses. It must be a contractual document. So like I said, if you want to rely on exemption clause and you want the court to approve it, it must be in a document that you both had agreed to. It must be in a contractual terms expressly stated by the both parties. You know, by so doing, it is seen that you had expressly stated that, oh, I will not be bound, I will not be repairing this phone for you. You are buying this my used phone from me. But if anything happens to me tomorrow, I am not liable. That's an exception clause. And if probably you are able to write it down, it's even carrying more weights if it is written down. But let's say, for example, somebody wants to buy, you went to slot, you went to buy a phone. After you had bought the phone, you had made payments. At the point of making payments, you have made payment, they now wrote a receipt for you. And under the receipt, you know, at times, if you look at most receipts, they will write some teeny, tiny things under those receipts. Another, they will be saying that they are not liable if anything happens to the phone tomorrow. Those will not be agreed by the court. because that is unfair. It is not, the both parties did not agree to it. It's just one-sided. I hope that is understood. So Lawale, yes, the one that has a lower bargaining power will be supported by the law. Please, do you understand this A part of exceptions to bargaining power? So to exception clauses. And number two, I say notice. Notices that are hung. I give an example of when notices are hung in the room where you rented, or maybe you want to enter. Yeah, let me use that room. It is well understood. You are at the reception. They won't tell you that whatever you take into this room, it is at your risk. It's when you enter that they will tell you that you'll be seeing it that is hung somewhere that, you know, that it is a risk for you to put your items in here. And the next one, we said signature. You know, there are sometimes that immediately it is agreed that for you to say you are going to rely on exemption clauses, the signature, if the both parties had signed on that paper, it is seen as that exemption clause taking effect, except if that thing is entered into under duress, except a person or would I say, except the person sign an agreement under duress. If not, if the person did not sign under duress, if a paper containing an exemption clause is signed by the both parties, the exemption clause would be approved by the courts. And so we'll start from capacity in our next class. Please, do you understand me? Are we good to go?
Yeah.
So Oliver, can you please pin down the question you have before? Can I see that question you asked about wages board and all? Okay, please. So you said that. Let me see if I can just click on it. And oh, it's gone. So you said, does the Wages Board and Industrial Council Act applicable to the informal sector? Of course, it is applicable. It's just that most of the times, employees will not want to go to courts because they don't want to lose their job. It also applies to them, especially, I think, especially employment that has more than 5 or 6 people as their employees. It binds them. So also, what is happening now? Well, I can't see the chart again. No. Okay, said in OMO online, an implied contractual term based on acquiring a landed property. I don't understand you. But Oliver,
I
you
mean
said
omonile.
OMO online.
Omonile. Not online. I mean
What do you
omonile.
mean? In OMO
Eh,
online, an implied
Excuse
contractual
me, can
term
you hear me?
based on acquiring a landed property.
Hello, ma.
Okay, so I don't understand if you can type it again before I end the class.
Sorry, ma. I meant omonile.
Do you want to type it, Oliver? I don't understand it. If not, can we go? She can't hear me. Oh, but can every other person hear me?
Hello, ma. Can you hear me?
But why can I not hear you? I can't hear you. I cannot hear you. What happened? Okay, Yoruba term. Okay, so you can unmute yourself. Oliver, unmute yourself. You can say it, unmute yourself before I end the class.
Okay, ma. Can you hear me? Hello? Hello, ma.
What happened? Why can I not hear you? I can't hear you. Oh, Omonile. Okay. Okay, so please, can you come up again? Please pin in your question again. Okay, he said, is Omonile an implied contractual time based on acquiring? I don't understand very well, that you went to buy property from Omonile. Yeah, and that there was an implied contractual term. You know what? Anything that is commercial, Omonile or not, if it is commercial and landed property is commercial, you went to buy something from them, it is going to be enforceable under the law, or whatever. Of course, and one of the contractual, but most of the times when you are buying landed property, in fact, you write basically everything. I don't know if any of you have seen a landed agreement, a landed document. When it comes to landed documents, you write everything. In fact, it's so big as. Okay, he's saying that it's an implied contract to pay them. No, you cannot pay somebody and implied. You have to remember when we were talking about formal and informal contract. When it comes to landed property, it must be written, okay? It must be written, Oliver. And so that's the end of our class today. I wish you all the best. Do have a blessed evening. Bye.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma.